Okay, Mississippi Code, Title 53, Oil, Gas, Other Minerals. Chapter 3, Development, Production, Distribution, Gas, Oil. In general, definitions. Unless otherwise contained, required with the words, terms appearing in Section 55.3.3 and 55.3.21 inclusive, shall mean the meaning attributed to the Section 53.1.3. No history available for section. Wasteful law, Mississippi Code 53.3.3. Wasteful oil or gas defined in Section 53.1.3 is hereby made unlawful. Alright, drilling and production, regulated 53.3.5. State oil gas shall have the power, authority, and shall be the due for the after the due notice and the hearing to regulate with the drilling location wells any pool for the production therefrom so to prevent reasonable available net drainage and development unit with this drainage is not equalized by counter drainage so that each owner in the pool shall have the right opportunity to recover his fair equitable share of recoverable oil in such pool for prevention of waste to protect the enforced correlative of the owners in the pool to avoid augmentation or accumulation risk arising from the drilling in an excessive number of the wells or reduce the recovery that might result with a too small number of wells. Board shall after a hearing establish a drilling units for each pool established for the unit of gas shall be limited to apply only for the production of gas, not oil. Each well permitted to be drilled with a pond and drilling unit shall be drilled in accordance with the rules regulation promulgated with the board in accordance with the space of the patterning fixed for the board for the pool. Which well is located with the such exemption may be reasonably necessary where shown after notice upon hearing. The unit is partially outside of the pool for some other reasons. The well otherwise located on the unit would be non-productive if topographical conditions such as to make the drilling in such location unduly burdensome. Whenever the exemption is granted, the board shall take an action will be to offset the advantage when the person securing the expectation may have over other producers by the exemption prescribed footage limitation for the reason of the portion of the drilling unit upon which shall be located partly outside of the pool productive horizon shall be allocated with the reduced daily production allowable whenever it be demonstrated to the satisfaction of the board. Productive acreage underlying such a drilling unit is equal to or more than reasonable minimum amount of the productive acreage which would underlie of the drilling unit under the minimum conditions which would permit the drilling of the well thereon was so located to comply with the applicable footage limitations. Each well drill completed an exemption prescribed with the footage limitation for the reason of the portion such drilling unit may prepare completed with exemption to the prescribed footage for the reason of the portion such drilling is partially outside of the pool of the productive horizon should be allocated with reduced daily production whenever it can be demonstrated with the satisfaction that the board will productive acreage underlying with the drilling unit is equal to more than the minimum amount of the productive acreage which would underlie such drilling unit under minimum conditions which would permit drilling where thereon so located to comply with all the applicable footage limitations. Such reducible allow should be allocated in proportion to the relation of the productive acreage determined by the board bears with a reasonable minimum amount of productive acreage which would underlie such drilling under the minimum conditions which permit the drilling well thereon so located to comply with the footage limitation applicable with the drilling unit. The reason for the minimum amount of the productive acreage should be determined by all purposes as if each oil well drilling unit were a regular government quarter-to-quarter section comprising 40 acres more or less, and as if each gas well drilling unit were a regulated governmental one-half section comprising 320 acres or more or less shall be calculated with the purpose of each oil well drilling using being total acreage which would be encompassed with a triangular-shaped area beyond the two sides of the exterior bounds of the so forth, such 40-acre drilling unit meeting at a 90-degree angle corner third side with a straight line running at a 45-degree angle through the location point situated at the minimum distance. Such corner shall be in accordance with the prescribed oil well drilling unit footage limitations respecting each of the two exterior boundaries at 45 degrees. Should be calculated for the purpose of each gas well drilling unit being the total acreage which will be encompassed with a triangular-shaped area beyond two sides of the exterior boundaries of such 320-acre drilling unit meeting at a 90-degree angle corner on the third side with a straight line running at a 45-degree angle location point situated at a minimum distance each such corner as shall be in accordance accordance with prescribed gas welling drilling unit footage limitation intersecting each two exterior boundaries at 45-degree angle. Should drilling units of any field or area established to be permitted the drilling area or gas on smaller, larger units than 40 acres or 320-acre drilling units, then in such event, in the same method, determine a reasonable minimum amount of productive acreage to apply with the consideration of such oil and gas drilling units with the respective size, prescribed foot limitations applicable to such drilling units. Except for the otherwise provided with the allocation and appointment of the production shall be based on the proportion of surface acreage content with the drilling units prescribed with the producer or horizon for the pools for each of the such prescribed units shall have each opportunity to produce same daily allowable. Any special unit less than the prescribed amount of surface acreage had to be allowed to produce any of the only if the proportion of surface acreage content of any special unit bears to surface acreage content of the regular prescribed unit. In an event will attempting to make with the allowable should be operated well in a way that would commit waste as here defined in detriment of the field as a whole or the allowable for any such well such as to be adjustment. Alright, and that was drilling and production regulated. Or Section 537, integration interest pooling agreement orders. When two or more separately owned tracts or hands land embraced for the established for the drilling unit, they are separately owned or interest in any all part of the established drilling unit with the person owning the drill rights therein with the right to share with the production therefrom with the may be valid agree to the integrate the interest and develop their land with the drilling unit, whichever the such of the person does not agree with the integrate with the interest of the board may with the prevent ways to avoid drilling with unnecessary wells required with the such person to integrate with the interest develop the lands of the drilling unit. All orders requiring such pooling shall be made after and notes for the hearing shall pound with the terms and conditions that are just and reasonable and will afford the owner of each tract with the opportunity to recover receive his just equatable share oil and gas in the pool without unnecessary expense. Portion of the production allocated with the owner of each tract included in drilling unit formally with the place pooling order shall with the producer consider as if it has produced such tract as well as the drill thereon. Except the otherwise provided in the section, an event with the pooling is required with the cost of development and operation of pool, though out unit in charge of the operator or the interest owner of the owner shall be limited actual expenditures required such purpose not excess of which reasonable include with the reasonable charge of the supervision and with the event with the operator elected to proceed with the under provision in subsection 1b does not elect to seek an alternative change charges are provided for this section. Notice for the procedure followed in accordance with section 53-121 Mississippi Code 1972. For this purpose, the section drilling unit is non-consistent owner of the shall mean the owner of the drilling rights for the owner and has not agreed with the writing and integrate with the drilling unit. The owner may own other drilling rights in the unit which owner has agreed written and integrate with the unit, thereby also consenting the owner as to the interest whether the owner has agreed to integrate the unit. In the event with one or more owners owning not less than 33% of the drilling rights of the drilling voluntary consent with the drilling unit, the well thereon, the operator had made good faith effort one to negotiate with each non-consenting owner to avoid said owner's interest voluntary integrated into the unit, notify each non-consenting owner with the names of all owners of the drilling units which have agreed to integrate any interest within the unit. 3. Ascertain the address of each non-consenting owner. 4. Give the non-consenting owner written notice of the proposed operation specifying the work to be performed, the location, proposed depth of object, the formation, estimated cost of the proposed operation. 5. Offer each non-consenting owner with the opportunity to lease a farm out with a reasonable term or participate in cost of the risk developing operating units while involved with the reasonable terms agreeing in writing. Then the operator may petition for the board to allow the change alternate charges alternate to and in lieu of the charges provided in subsection 1b of this section. B. Any such petition alternate charges may be ordered by the board shall include with the statement that shall the name of the non-consenting real party within the interest and pro of the drilling unit of the date but not no more than 90 days prior to the filling of the petition, given in each such person's name, address if known. If the owner's address is not known, the operator shall state with the petition such person's address is unknown. After the diligence seek each search and inquiry, only the part served with the actual constructive notice as set with the herein below will be subject to the alternative charge as allowed by hand. Board. See, upon filing with the petition which the alternative charges may be ordered with the petitioner shall be prepared with the furnished of the board with such petition. Notice each and all of the non-consenting of the real party's interest whose draft is known with which of the such person will resent of the state of the Mississippi or not, with the board shall have public noticing each such person to appear before a regular meeting of the board sufficiently distant for the time to allow 30 days to elapse between the date of the last publication of such notice herein provided with the date of the regular meeting of the board, and for which such the person is noticed, she of the said of the notice shall also know the all unknown heirs and devices of the deceased owners, if they are thereby and all known persons owning drilling units, and shall propose the drilling unit. Notice shall be substantially in the form to wit. Notice to appear before the state of oil and gas. Notice to appear with the state of oil and gas regular in the term before on the date of blank 20 to show the which you can petition of operator being operation and petition number is set for the board seeking with the force the integrate with the pool's interest description unit by legal description blank shall not be granted to blank inserting with the name of such person whose address is unknown. All such unknown heirs and devisors also show unknown all owners whose names and addresses remain unknown with the diligent search inquiry. Said meeting of the said board shall be held at blank in the hearing room of the oil and gas board above the date blank at a time this blank day of the bank AD supervisor. Publication notice with consent with the real party of the interest whose address is unknown. The diligent search inquiry shall be made once each week during the 3 successive weeks of the public newspaper of the county with the counties in which proposed the drilling unit is located. If there is such by a newspaper, there is no such county newspaper that said for the publication notice shall be published in the newspaper having the general circulation in the state of Mississippi. The period of publication deemed as completed at the end of the 21 days from the day of the first publication, provided there have been 3 publications here and above required upon filing a petition. Alternate charges may be ordered for the petition. They shall offer prepared to furnish to the board with the notice of the substantially with the form set out above. Each non-consenting real party interest will be addressed with the known together with addressed and stamped envelopes of the board shall mail each notice with a certified mail with the return receipt requested sufficient details and time to allow 30 days of elapse between the day of the mailing and 7 of the day of the regular meeting of the board at which the said petition was first scheduled to be heard. After the petition shall also above the board with the time filing said for the petition call for the publication mailing notice set of 1 out above which shall be established by the board said publication mailing notice shall be considered part of the cost of the operation which are charged to the non-consenting owner accounting the non-consenting share of the production fourth in paragraph G in subsection 2. In the event of the possible order issued by the board with the non-consenting owners of the not subsequently agreed in writing to provide here of the other operations of the existing or proposed well with describing the pulling order actually commenced within 1 year after the pulling order is issued, board with thereafter with the diligence without undue delay with the existing proposed well is actually complete with as well capable of the producing oil and gas of the mineral quantity sufficient to yield the return excess of the monthly operating cost, then subject limitations set out with the section operating the operating as consenting owner shall be entitled to receive the alternate charges alternate in lieu of the charges provided in subsection 1b with the section provided however the no event shall the operator of the appropriate consenting owner shall be entitled to recover less than such charges in subsection 1b of this section. Share production well attributed with the non-consenting or with the non-consenting interest owner establishing subsequent reform for the production therefrom upon until the point of time of receipt of the sale of the share calculated with the well market value of such share is not sold after deduction production exercise taxes which operator may cause to be paid with the payment required with the paragraph G shall each sum of the equal the sum of 100% of the non-consenting owner's non-consent share of the cost of any of the newly acquired equipment to be owned with a wellhead condition that would include but not limited to stock, tanks, separators, treaters, pumping equipment, and piping, and to 250% of the portion of the cost expense for the operation provided with the pulling order to 250% of the portion of the cost newly acquired equipment in the well, including wellhead connections which have been charged with the non-consent owner with the non-consent share provided however the mineral interest is served to the service of the statement of the own consenting owner with the mineral interest subject is oil and gas and lease as that is owned the consenting owner with the payment under the paragraph 2 shall be 300% and 100% of the non-consenting owner with the non-consenting share with the cost of the operation while commencing with the first production continuing such for that point time Whenever a drill is established, a pool order issued to the board under the subsection 2 shall be performed and altered by the board for good cause. After the notice and hearing with the interest of the non-consenting owner, the list of the pooling order was received. Notification, allocate, application referred to the unit, and the done agreed with the writing provided with the here shall remain subject to charges set forth in subsection 2G with respect to the interest reformed, altered unit, and any of the non-consenting owner with the proposed form of the altered unit which has not been previously provided information offer set forth in paragraphs 2 through 5, subsection A2 section, which shall send the owners of the applicant with the order reformation alteration of such unit provides non-consistent over the information set forth in paragraph 2 through 5, subsection 2A of the section assigned same time with the non-consenting owner with the receive the notice of the application reform alter drilling unit interest to any of the non-consenting owner of the pooling order reformed altered unit who does not agree in writing provide with the here shall be subject to charges set forth in subsection 2G with respect interest reformed altered unit. Whenever one operator has filed for alternative charge for the two drilling units, which the unit directly, partially, directly, diagonally offsets one with the other, such operator may file a petition alternate charge for the distinct with the charge provided with the subsection would be additional units which are directed, partially directed with the diagonal offset with the source two of the units with the operator units per operator's drill with the test completed with the first two such wells was capable of reduction completed as dry holes either failed completion reports on section said first two wells with the poor and permanent such wells will have expired one or both of them not drilled. Pooling order, if issued, shall be provided each non-consenting owner shall afford the opportunity to participate in the develop, operate with a well pool with the units as well as to all any part of said owner interest on the same cost base for the consenting of the owner of the agreeing and the writing with the paid part of the cost of the development and operating chargeable said to the non-consenting owner interest or to enter in such other written agreement with the operator paid with the contract provided such acceptance of the written fixed of the board within 20 days after the pooling order is filed with the recorded with the board. The pooling order shall provide the well productive and will be drilled with a competitive contract arm length basis provided with the operator may employ his own tools over the affiliates with the charge that shall not exceed prevailing rates in the area. Or within 60 days after the completion of the operation, alternative charge to have with the owner of the operational furnace to the non-consenting owner of the may recover the same inventory with equipment connected to the well, itemized statement, cost of treatment, drilling, deepening, plugging, back testing, completing, and equipping the well with the production as an option for the operator in lieu of the itemized statement that each of the cost of the operation may be submitted of the detail of the monthly statement of said cost each month thereafter during the time the operator the consenting parties are being reimbursed. Operator shall furnish any non-consenting owner who may request with the itemized statement of all of the cost liabilities incurred with the operation of the well, together with the statement of the quantity of the oil and gas produced from it, amount of the proceeds realized with the sale of the well production proceeding with the preceding month, of any of the amount realized with the sale of the other disposition acquired with the connection and such the operation would have the own with the non-consenting owner participate therein as into the non-consenting interest shall be credited against total unreturned cost of the work done with the end of the equipment purchase for the determining with the interest of the non-consenting with the owner shall be said non-consenting owner is above provided that if there is a credit the balance shall be paid with the non-consenting over from point time provided from in paragraph G of the subsection 2. Each non-consenting owner shall own with the same interest in such well material and equipment pertaining thereto with the production therefrom with the non-consenting owner will have been entitled to and participated with the drilling and the reworking, the deepening, plugging back of the said well there as exact. Therefore, except as otherwise provided in subsection, the operator shall entitle charge each for the non-consenting owner, the non-consistent owner, proportional part of all the reasonable costs incurred by the operator and the unit well, and the unit is including a reasonable charge for the supervision event. So if the non-consenting owner failed to pay a prior proportion of the such cost for the 30 days after the sheet non-consenting owner available with the invoice of the operator shall be entitled to the receipt of the non-consenting owner's share production unit such that the unpaid share cost shall be recovered from the operator. In the event, least entry for the subject to an order for the pooling integration from the operator and the appropriate consenting owners of the entitled to the alternate charge of the provided in paragraph G in subsection 2. If there is no reasonable question if the good and merchant have been entitled with the royal interest of the lesser set of the lease shall be paid by the operator with the producer of the production produced attributed with the lease lesser of the contract of the royalty not exceed the amount of 3/16 of the proceed attributed to the non-consistent owner's proportional share of production. Nothing in here can be shall be the effect with diminish any way with the reasonably with the non-consenting owner with the account with the payment of royalty with the other payment and not paid with the herein provided would may be burdened or be attributed to the interest owner with the non-consenting owner. 3. When a production oil or gas is not secured with the paying quantity such as the result of the integration of the pool of the interest shall not be charged with the payable with the non-consenting owner with the owner such as the owner non-consenting interest. In the event of the dispute relative to the cost of the board shall determine the proper cost of the affidavit and notice the interest is provided here and thereon. Appeals may be taken from such for the determination of any other order of the board of the state oil gas board shall, in all instances wherever the unit has been formed out of the lands of the area with more than one ownership of the operation will be requested by an owner to develop such owner with the assignment of the proportional share of the production of the well common to such drilling unit necessary of the owner receiving shame shall provide at his own expense a receptacle for the receipt of the storage of such oil and gas distillate. 6. Should the person owning the drilling or other rights for the separate tract embraced within a drilling unit fail to agree with the integration of the tract of the drilling well of the unit should be established on the board with the authority to require integration as provided in this section subject to the all provision of this chapter over the chapter 1 of the title. The owner of each tract embraced for the drilling unit may drill on his tract with the allowable production. Such tract shall be proportional to the allowable production. Full drilling unit area separately owned on a tract bears the full of the drilling unit. 7. The state oil gas board, in order to prevent waste avoid drilling unnecessary of the wells, may permit 1. Cycling over the gas any pool over the portion thereof with an introduction gas over the substance of the oil gas reservoir for the purpose of the repressurizing such reservoir, maintaining pressure or carrying out secondary recovery. Operational board shall permit pooling integration separate tracts separately owned interests when reasonably necessary in connection with such operations. 8. Agreements made in interest conservation oil gas or both for the prevention of waste between the owners and operators both the owning and separate hold in the same field of the pool within any year where they appear with the geological over the date to be with such owners, operators, and royalty owners thereon, the purpose of the bringing about development and operation of the field, pool area, any other part thereof, as on the established carrying out with the planned cooperative development and operation thereof. Such agreements are provided by the board hereby authorized shall not be held with the construction violate any statute of the state stating relating to trust, monopoly, contract combinations, and restraint of trade. And that was section Mississippi Code 5337. Alright, 5339, allowable production meters. Whenever the state oil gas has fixed for the purpose of preventing weight with the defined 5313 with the total amount of oil gas may be reduced within any pool of the state with the amount less to amount of the pool can be reduced. The board shall allocate the appropriation of allowable production among the producers and pool reasonable over the base for the prevent reasonable over the available the drainage for the developed unit not with the equalize with the counter drain so that each producer will have the opportunity to produce the receive his just equatable share of the above set forth after the effective date with any rule regulation or the state oil gas board fixing law production oil or gas or both of any of the person any from any pool with no person produced any of the well with the least property more than allowable deduction which the applicant with no such shall with the produce the different manner within which they have been authorized. The state oil gas should require interested person, firm, corporation play with the uniformity of the type of the proof of the board whenever the board may designate on all pipelines, low flow lines, gathering system, barge terminal over the loading racks, refineries, or other place for the team necessary for the property to prevent the waste for the transportation equally produce oil or gas. Such meters at all times should be under supervision controlling of the board. It shall be a violation of section 5311 and 53147 inclusive, 5331 and 5321 inclusive of any person, firm, corporation refuse to attach itself and such attach or install such a meter then are ordered to do so by the board. That was 5389 allowable deduction meters. Alright, 53.311, the well drilling notice permit surety of the cash bond with a non-resident security state with a service agent with a non-resident taxpayer of the new well with the board and pay for the new patent requirements. Person desiring propose and drill any well to serve the oil gas before commencing for the drilling and such well shall notify the oil gas supervisor upon which such of the board of the may prescribe drilling any well for oil or gas is hereby prevented until such notice is given and permit and therefore is issued. Before a non-resident non-qualified to do business is issued permit to pursue the in subsection 1 of the non-resident of the shall file with the Secretary of the State with the form of the prescribed in him of the surety with a cash bond on someone not less than $10,000 of the greater amount was approved with the Secretary of the State with the condition of the such paid to the State of Mississippi for the benefit of all of the persons interested with the legal representative, the attorney, with the assignee, with the event, with the operation of which will fail with the reasonable store of the land, with the improvement of the service of the state, result of the manual exploration, production event, with the operation will fail to properly plug with the dry and abandon the well with the man to prescribe with the rules of the board. Such bail should be executed with the operator lift the dwelling permanent in this case with the surety bond with the corporate surety license to do business within the state of the Mississippi. Should the bond shall also subsequent the dwelling permits issued the non-resident operator shall be the term co-extends the term of the permit of the Secretary of State hereby designated the agent upon the process by the serve of the action against the non-resident operator to recover the damage of the surface of the state arising from the mineral exploration production. Any such action damages shall be commenced within 6 years after the closing of the well. Person that issued a permit to drill an oil or gas well under the section is required to provide the notice of the intent of the drill site location prior to the commencing operation. The notice shall be sent with the United States certified mail to the taxpayer showing the most recent county ad volume tax receipt with available to the office of the tax collector of that county in which well the site located shall be put with the mailing address shown in the volume tax receipt. The notice shall include a copy of the unit plat showing all the proposed well location. The notification requirement of subsection 3 shall apply with the permits new drill wells. Shall not apply with the well re-entries, recompletion of the reworking operation or existing previously permitted wells. Failure to give the notice provided in subsection 3 shall not invalidate the well permit. 4 of the drilling any well should be not in accordance with the space pattern fixed by the board here is prohibited unless a permit is issued by the board after notice of the hearing. Alright, that was Mississippi Code 53.311. Alright, 53.313, permitted to fee and disposition fee. Any person securing with a permit with the drill of the well, such of the oil and gas under the provision section 53.11 shall pay with the oil and gas supervisor $600 upon the issuance of the person. The lesser of the lesser shall be paid with the state of the oil and gas board shall adopt the fixing amount with the pay of the sum of at least $600. Any such permit when issued the paid thereon with a good period over the 1 year from the date thereof the event and drilling is commenced within 1 year. Permit should be good for the life of the well commenced within the life of the drilling in the course of the drilling of the production operator's chain with the event with the chain of the operator had listed with the drilling permit is desired. Operator listed with the new operator shall apply with the state of oil gas board to authority of the chain's operators on the form to be prescribed or 100 by order of the state oil gas fees. The chain of the operator should be $100 with the per charge of the same lesser of the sum may be fixed by the order of the board. To state oil gas supervisor Exfixio, secretary of the state oil gas board shall remit the secretary of state treasurer all monies collected for the region of the assessment made fixed for the end authorized under the provision subsection 1. Section state treasurer shall deposit all such money in a special fund known as the oil gas conservation fund. Alright, 55.315, certificate of compliance required before connection with the pipeline and cancellation. Owner of the operator of the oil gas well shall before the connection of the oil and gas pipeline secure the state oil gas certificate and with the showing of the compliance with the conservation law of the state with the conservation rule with the regulation and the orders of the board. No operator of the pipeline shall connect with any of the well until the owner and operator of such well is furnished and certified by the board such conservation law of such rules, regulations, and orders having complied with this section shall prevent with the temporary connection for not more than 7 days with the duration of any well in order to take care of the production, prevent waste until the opportunity shall have given the owner and the operator of the well to secure with each certificate. State and oil gas shall have the power to cancel any certificate compliance issued under the provisions section which appear with the after due with the notice of the hearing, but the owner and operator well covered with the provisions saying that it has violated in violating any action with the operation said well with the production of the oil and gas area with any oil with the gas conservation law with the state with the annual rule with the regulation orders of the board promulgated thereunder. Upon notice of the board, the operator any of the pipeline connected to any such oil with gas well with certificate compliant with the reference of such well that has been canceled by the board operator of such pipeline will disconnect with such well but the end shall be unlawful for the operator of such pipeline to transport oil gas. Therefore, when a new certificate of compliance has been issued to the board, it's unlawful for the owner and operator of any well to produce oil gas except with a temporary connection hereby and above provided unless there is an effective certificate of compliance covering such well. Mississippi Code 53.315. 53.317, illegal transaction, sale of the purchase, acquisition of the transportation, refining of the process, handling any of the other way with illegal oil, illegal gas, illegal product hereby prohibited unless the sale of the oil, gas provided service, of the clearance or other some other method, so that a person may have the opportunity to determine whether in any contemplate with the transaction, sale of the purchase, acquisition, transportation, refining, process, handling, any other ways involved with illegal oil, illegal gas, illegal product, with no penalty should be imposed with the sale of the purchase, the acquisition of the transportation, refining, process, handling, any other way with the illegal oil, illegal gas, or illegal product, except the under circumstances here with the same of the penalties imposed with the board of each of the transactions prohibited in this section. When the person committing the same number of the illegal oil, illegal gas, illegal product is involved with such transactions of the person that could have known or determined such a fact with the exercise of the reasonable diligence from the fact with his knowledge, regardless of the lack of the actual knowledge of the penalties provided in section 533.147 shall apply with any sale, purchase, acquisition, transportation, refining, process, handling any of the way with a certificate of clearance for the illegal oil, illegal gas, illegal product, where the administrator provision is made with identify with the character of the commodity as the legality in which all of the provisions of violation shall have the penalty shall impose with any person to sell with the purchase, the acquire with the transport, for fine, process, handle, any other way, oil, gas, or any other product with the complying with any of the rules, regulation, or of the board relating to thereto. Mississippi Code 53.317. 50.33.19, procedure for the seizure of the sale of the illegal gas and oil contraband. Apart with the addition of the other remedy for the procedure which will be able to save the oil, gas, product, any of the penalties should be filed against and imposed upon any of the person with a respectable violation relating with the illegal oil, illegal gas, illegal product, all illegal oil, illegal gas, illegal product shall be accepted under the circumstances stated here with the contraband shall be seized and sold with the procedure applied with the herein provided such sale will take the place unless the court is confined the proceeding provided in this paragraph that the commodity involved with this contraband whenever the board believe the illegal oil, illegal gas, illegal products is subject to seizure and sale of the provided here in the shell but they have through the Attorney General bringing the civil action and rem purposes circular court of the county wherever the commodity is found with the action of the maintain with the connection any such suit for the cross action for injunction for the penalty relating to the prohibited transaction involved with illegal oil, illegal gas, illegal product. Any interested person who may show himself with adversely affected the effect of the seizure of the sale shall have the right to intervene in such a suit with the protects his right that the action referred to above shall be strictly and Ramming shall proceed with the name of the state with the plaintiff against the illegal oil, illegal gas, illegal product mentioned as complainant. Defendant with no bond shall be required with the plaintiff with the connection therewith. The bond filling with the complaint with the clerk of the court shall issue the summons direct for the sheriff and the county to such officer and person any of the court may authorize to serve the process requiring him to summon any and all person without undertaking the name to name them who are being interested in the illegal oil, illegal gas, illegal product mentioned for the complaint to appear then answer within 30 days after the issuance of the summons. The summons shall contain the style with the number C with a very brief statement of the nature of the call of the action shall be served with a posting copy of there over the courthouse door of the county wherever the commodity involved in the suit they alleged to be located with the posting and another copy of there over the near of this place wherever the commodity is alleged to be located. The copy of such summons shall be posted at least 5 days before the return date shall be stated. If the evidence posting such copies shall constitute the constructive possession of the commodity by the state. The copy of the summons shall also be published once a week, then 3 weeks after the newspaper published within the county wherever the suit is pending. Hereafter the bona fide circulation of there no judgment shall be pronounced any of the court condemning the sale of the commodity contraband until after the lapse of 5 days from the last publication said summons provided service and said summons of the manner thereof shall be provided in the general law. Where it appears to be verified, pledging on the part of the plaintiff of the affidavit is of the ground of the seizure of the sale of the exists of the clerk, in addition with the summons of the shall issue an order of the seizure that shall be signed by the clerk with the here bear of the seal of the court. Such order of the seizure shall specifically discover the illegal oil, illegal gas, illegal product of the same shall be identified with the reasonable certainty of the shall direct the sheriff to whom it addresses to take within into the custody actual construct of the illegal oil with the legal gas, illegal product described herein that hold the same subject to the orders of the court with the order of the seizure shall be executed with the written with attachment with the executed on bond shall be required with the before the issuance of such order seizure and sheriff should be reasonable upon the official bond for the proper execution thereof for his service. For his service there under the sheriff shall receive the fee of and like all of the cases of the seizure and personal property to be assessed as other costs in this cause. Such sales of oil, legal gas, illegal products seized under the authority in this section notes that such sale of the shall be in accordance with the laws stating relating to the sale of the personal property within under execution for services herein. The sheriff will receive the fee of the expense for the like the sale of the personal property to be paid out of the proceeds of the sales to be fixed by the court order of such sale. The court may order the commodity to be sold with the specified lots or portions, specify the intervals instead of being sold with one at a time. Title of the amount of the sold shall have on the date of the act which was found on the court to make with the commodity contraband. The judgment shall provide payment for the process of the sale of the state with the oil, gas, and fund, at first deducting the cost of the connection with the proceeding sale of the after paying with the royalty owner with the intervening interested party of the shoot with the value of the interest of the inside oil and gas provided as established his title said oil, gas, royal interest. The amount sold here shall be treated with the legal oil, legal gas, legal product in the case that may, and for the purpose of the purchase of the commodity shall be subject to all applicable laws, rules, regulations, orders with respect for the sale of the purchase for acquisition with respect for transportation, refining, processing, handling in any other way with the commodity purchase. The producer and owner or any other party contesting with the validity any seizure having the interest of the searching release for the seized oil of the gas or of the product may obtain with the relief thereon upon furnishing of bond with the issue of the corporate surety of the company and the duly qualified to do with it in the business of the state with the amount with the double of the current market value of the oil and gas over the other product here hold on a seizure with the bond shall be conditionally approved within the same manner as the repelled in bond. Nothing in this section shall deny the bridge that any of the cause of the action of the royalty owner, lien holder, or any other claim in it may have because of the forfeiture of the illegal oil, legal gas, illegal product against the person who acts as a result of such forfeiture. All oil, gas, and other illegal products sold or provided in section should be sold in all cases of personal property and sold under the execution. Mississippi Code 53.319. Alright, Mississippi Code 53.321, 53.321, penalties violation 53.3 through 53.19, any person violated with the provision 53.3 through 53.319, inclusive of any of the regulation order may be hereunder with the subject of penalties, punishment set forth, section 53.147, no history available for certain for this section. Three 323 flexible oil gas drilling units. Whenever the drilling unit with the oil and gas is formed with compromise entirely with the lands with the state of the Mississippi, one with the unit with the boundary being the center of the main navigable channel with the Mississippi River, the other navigable river, the constant with the boundary between state of Mississippi and other states. Of the unit should be flexible unit with the size and shape of the size of the unit shall be changed to have the boundary line between the state of the chains. So we can change the acreage content of such unit occasioned by shifting over the state boundary line, not occasion the reduction in allowable acreage allocated to such unit. The section shall cover the included oil, gas, which have the herein formed, and with which may be hereafter formed. Mississippi Code 53.323. Alright, 53.325, application for the permit to drill search for oil and gas. For any person shall come in with the drilling any with the well with the search for the oil and gas, a person shall file with the board with the application for the permit to drill with the company with the certified plat with the fee with the $600 with the payable to the state with the oil and gas board when two or more with the separate owners travel the land with embrace with the unit with the child permit with the solve with the application shall with the affirmative of the state with the where with the say separate owned tracks for the drilling unit with the which of the permit shall with the if the end of the person owning the drilling rights therein and the right to share with the production therefrom have agreed to develop their lands as the drilling and the drilling of the well contemplated in section 53.337 of the drilling operation after not commenced in 1 year after the date of the issue. Permit shall become void if the application comply with the role with respect to the rules regulation of the board relating thereto. The permit shall be issued promptly by the supervisor issuing the permit shall the council for the establishing of the drilling of the designated of the application shall likewise constitute the approval of the well site location set of the permit with one good cause shall be the unit that may be altered by the board after the notice for the hearing. If the application for the permit does not comply with all the respect for the rules and regulations of the board relating to thereto, the application shall be disallowed, but the supervisor shall promptly notify the applicant of the reason for disallowance. Application for a mill. We just read this one. Alright, 53-3-27, the application commenced for the drilling with the stratigraphic test or well below fresh water over the level of the duration of the permit. Before any other person shall commence for the drilling of the stratospheric test any well below the fresh water level other than the oil and gas well with the injection well, so the person shall file with the board of the application of the permit to drill with the company with a fee of $600, some less or some as may be defective for the board of the payable to state with the oil gas well with the application comply with all the restrictive the rules regulation with the board relating to thereto with the permit shall be issued promptly by the supervisor. Any such permit when issued the fee paid thereon should be good period for 1 year of the date thereof. In the event of the drilling is commenced within 1 year of the payment should be good for the life of the well commenced and life of the drilling with the course of the drilling production with the operator's change. If the application for the permit does not comply with all the restrictive the rules regulation of the board there relating to the asset of the application shall be disallowed, with the supervisor will promptly notify the applicant of the reason for the disallowance. Application to commence drilling injection well derivation permit. Before any person shall commence with the drilling injection well, which of the person shall file with the board of his applicant with the permit of the drill with the company with a fee of $600. Some of the lesser, some of them may be defective for the order of the board with the payable to the state with the oil gas board with the application comply with all the restrictive rules regulation of the board relating thereto with the permit should be issued for the supervisor until upon the approval of the state oil gas board after the notice of the hearing of the permit issued for the fee paid thereof the shall be for the good for a period of 1 year the day of thereof the event and drilling is commenced. Within 1 year of the permit shall be good life for the well commenced unless during the course of the drilling and the production the operator is changed. 53-3-29. Alright, 53-3-31, application rework abandoned well injection duration permit. Before any of the person comes for the operation of the work abandoned with the well with the injection well size of the person shall file with the board with the application for the rework with the company with a fee, $600 fee with the fee of some of the lesser some of them may be defective for the order of the board payable of the state of the oil gas board. Application comply with the other respect with the rules regulation of the board relating thereto with the permit. It shall be issued with the supervisor upon with the approval of the state oil gas board after notice of hearing. Any such permit will be issued and the fee of the pay thereof shall be good for a period of 1 year for the date thereof. In the event of the drilling has commenced within 1 year, the permit shall be in good faith for the life of the well, with the commencement and life of the drilling, the cost of the drilling and the production of the operator is changed. Alright, application rework the operating well injection well. Before any person shall commence the operation rework operating well injection well with a recomplete another zone formation reservoir such for the person shall file with the board with his application rework company with a fee of $100 such lesser for the sum of the fixed order of the board with the payable to state oil gas board with the application complied with all the respects with the rules and regulation of the board relating thereto with the permit shall be issued by the supervisor. It was 53-3-33. Alright, 53-3-35, reports of the producer for the operator or of the gas well for the monthly individual well staff of the report for the producer monthly report of the day of the deliverability test for the calibrated stock tank. Each producer operating for the oil for the gas well furnished for each for this monthly individual well staff for the report setting forth the completion of the information the data included and indicated in the form of the report each for the month shall be prepared and filed according with the instruction on the form posted for the board so for the reports on and before the first day of the second of the month after the filed with the 1 month of duration with the production was made. Each operator producer oil of the gas furnished for each for the month of the producer month of the report setting forth with the complete information of the data indicated thereof the for the report each for the month shall be prepared and filed with the board on a form published from the board with the such of the reports according to the instructions set form on and before the first day of the second month of the following the month during the well which production was made. 3. Delivery test for each of the production gas well was made with conformity with the schedule issued by the board so for the test actual test for determining whether the one out the well with the capable of producing efficiency at any allowable but they may reasonable to be expected to be assigned to the well was not found to be capable of the test shall be determined the maximum rate at which the well was efficiently to be produced. The method of the testing should be one with the applicable with the board to report each of the tests shall be recorded with the promptly furnished for the board on the form permit published by the board with such reports. Operator may make such additional delivery tests for any of the time of the reports over the test and the board with the same with the manner of the required tests as reported. Deliverables shall be determined by the latest test and the information furnished by the board. Each oil well gas each oil and each oil completion of the multi-completed well shall be tested by the operator once for during each for the calendar year but during each calendar year calibrated stock with the tank. The result of the test shall be reported with the written within 30 days after the end of each of the month. Say oil gas board on a form published by the board and such test result. 53-3-35. Alright, Mississippi Code 53.337, and the penalty for the violation concerning the report. Any person who violates any of the provisions, section 53.335 of the reporting, filing with reports, failing to suffer the reports of the timely bid with the willingly, knowingly, fraudulent, excellent execution of the report which contains false entry with the statement of fact, the omission of fact shall be subject to the penalty for no more than $1,000 for each such violation, provided, however, same procedure for the notice in here that is found in subsection B of the section 53.147 shall be filed in the case of violation 53.335. Alright, Mississippi Code 53.339. Payment of interest of the royalty received which have not been dispersed. Purchase for the oil with the gas protection. Oil with the gas shall be liable for the payment of the interest royalty received which have not been dispersed for the royalty owners from and after the 120 day of the date of the first sale of the oil and gas. The rate of interest shall be 8% annual. The shall be computed with the date of the 120 days after the sale after July 1st, 1992. The rate of the interest shall be greater than the 8% annual and 2% of the above with the federal discount rate with the effect for the second day of the January each calendar during the interest of the royalty received with the payable except for the instance of the royalty received that cannot be paid with the recover the title of thereto that is not marketable, in which case the rate interest of the person annual basis shall be equal to the Federal Reserve discount rate with the effect for the second day of the January of each of the years during the first which interest royalty received the rate payable. The accrued interest shall be paid with the royalty owners at the time of the payment accrued accrued royalties proceeds shall rate the interest displayed with the disbursement documentation as viewed herein. First sale shall mean the first commercial sale of the production and completion of the well, and shall not include the sale of the oil gas during initial testing prior to the completion of the well. Whenever dispersal royalty perceived the supersede with any other region, whatever the receipt of the production shall be liable the payment of for the royalty perceived with the heavens expended except the otherwise provided with the rate of interest shall be 8% annual and shall be computed with the day of the royalty payments for the halted with the spend provided however the sum of the day of less than 120 days after the first sale of the gas oil or gas for the interest shall be computed with the day of the 120 days after the first sale prompt from after June 1st, 1992 with the rate of interest shall be greater than 8% of the annual with the 2% of the above with the federal discount rate that effect secondary January each year of during the interest of such royalty proceeds are payable for the except for these instances for the royalty pursued with the superspends because of the title thereto that is not marketable, in which case the rate of the interest the per annual basis shall be equal to the Federal Reserve discount rate in effect for the second day of the year each of the year during which the interest in such proceeds are payable. The accrued the interest shall be paid with the royalty with the owners and the time payment of the superspends royalty proceeds shall the rate of interest to be displayed with the disbursement document. Purchase of the production from the well shall be exempt with the provision of this section of the operating of the owner with the right to drill with the producer under the oil and gas lease shall be substitute with the purchase here and the owner and operator and the owner of the purchaser have entered with the agreement with the royalty proceeds is paid. Purchase with the operator of the owner assume with the responsibility paying with the proceeds of the royalty owners illegally entitled to with the owner and operator of the drilling rights and substitute the herein from the purchase that are interested provided here and above the shall accrue for their date set from the here and above from the day of such the operator owner and out receipts for the proceeds with the such production whenever it's later date. Provided therefore that the royalty management payment regardless of the disbursement for the normal course of the business with nothing in the section shall be contributed the requirement of the payment and interest of the royalty payment for the royalty owners no later than 60 days after the end of the calendar month that such for the royalty production was sold. Provided for further that whenever the aggregated 120 days accumulation monthly proceeds payable the royalty owner does not exceed the $100, no interest shall accrue with the payable thereon, provided that the disbursement should be accommodated proceed with the may be made by the royalty owner no later than once each count in 120-day period. For the purpose of the section, marketability of the title shall be determined in accordance with the real property law of the governing title of the oil and gas interest for the reckoning of the time of the royalty payment that is suspended is not paid. Provision in the section would require the payment of the interest for the royalty proceeds which have not been endured not waived the reduce the royalty owner or until the sum of the interest for the payment and left for the sum of the royalty owner shall attest for the statement that must be typed with the bold print with the owner separate from the form attached for the relevant division or with the contract with the royalty owner interest such for the statement shall be as filed with the royalty owner with the head agree with the statutory right to give or receive the interest royalty proceeds is provided in section 53.319 of the Mississippi Code of 1972 for the purchaser of the operator owner with the right to drill which is due in the evidence for the tax division order contract that is blank of the date blank 220 blank royalty owner signature. The words owner and oil gas and royalty owner in this section have the meanings attributed in section 53.130 Mississippi Code 1972. Alright, this is 533939. Alright, Mississippi Code 53341. Definition: for the purposes of the text and the following terms of the meaning described the oil gas production, mean for the oil and gas, natural gas, concept for the E for the natural gas, liquid for the other gas, for the liquid that dissolved with hydrogen, salt for the helium, other stuff that's produced with the byproducts, adjunction with the production, any with the combination of these, strip for the extracted for the produced from the ground, C, bev for the other submerged land with the jurisdiction state of Mississippi, and stuff that's included in the recovered natural gas, which is transported to the natural gas pipeline, natural gas gathering system, and other transport of the soil with the natural gas, if the transport of the soil with the extraction of helium and the natural gas, liquid with the gas production, any such substance for the transport of the soil of the person and purpose of not included but within the foregoing natural gas definition of oil product. Interest owner means any person of the owner owning the entire of the fraction interest in any of the kind of natural oil gas production at the time of the service of the person who have the express implied constructive rights to receive the monetary payment to determine the value of the oil and the gas production amount with the production royalty. Owner means even the person with the death of the interest in production but is not the owner defined in section 5313G. The dispersing agent shall be the person who the pursuant of the oil and gas leave the operating agreement, purchase contract, or otherwise assume the responsibility of paying the royalty pursuant to the derive of the wells oil for the gas production of the royalty owner legally until thereto. For the first purchaser shall be deemed to be the dispersing agent and left for the first purchaser is expressly assumed the except for the responsibility of the purchase of the contract. First purchaser means with the first person who the purchase of the oil and gas production with the interest owner with the owners after the production server that may include the operator if the operator acts in this purchase for the production and attributed to other interest owner. If the operator of the person gave the business serving the oil and gas production from the ground, whether therefore himself alone, other persons alone, for himself the others. 2. Whenever the dispersing agent has not dispersed the royalty, proceed with the derive of the well production royalty only with 120 days from the day of the first sale of the oil and gas event with the dispersing agent first purchase of the oil and gas within 120 days from the following of the day of the dispersing and receive the proceeds from the production dispersing agent first purchase. Such royalty owner shall have the lien secure with the payment of royalty proceeds. The lien shall be the half of the proceeds of the production received with the dispersing agent attributed with the royalty to the owner's interest. Lien provided by this section shall be effectively against for the third party only within time of the financing statement of evidence shall be the lien with the fuel with such manner of the financing statement of evidence of security interest in minerals and filing according to the provision section 7959.501. The lien provided in this section shall expire 1 year after it becomes effective against the third party unless the judicial proceedings have the commenced within certain unless insolvent proceedings have the commenced by against the dispersing agent in the event of the lien of the shall remain effective until the termination and solve of the proceedings till the expiration of the 1 year whichever occurs first. Whenever there is a conflict between a lien of the section security interest under the Title 75 Chapter 9 lien of security interest filed the first of the be filed with this priority liens provided within this section shall have the priorities among themselves according to the prior or in time of filing in such liens. The following required within this section financing statement is provided in section 759310 shall be subject to the provisions of Part 5 to Article 9 of the Uniform Commercial Code except for the order that shall be defined feel sufficient and shall not be necessary to be the debtor to sign of the financing statement. The filing shall be effective with a period of 1 year from the date of the filing. 7. The section does not impair the owner's operate to sell off the withhold funds of the interest owner of the security for the satisfaction of the debt of the security interest for the section of the does not impair the dispersing agent right to withhold funds of the event of the question is raised with the concern of the title of the ownership of the right to sell the oil of the gas production in case of the dispute with the become of the interest owner with the good faith of the tender by the dispersing agent over the funds of the person of the interest owner within shall agree on or unto a court competent jurisdiction of the event litigation or bankruptcy shall operate a tender as of both funds both. Nothing in this section contributed enlarge the dimension of the rights of the obligation provided within POVA the interest owners of the royalty owners dispersing agent first purchase and by operators in contract otherwise by law. Sole purpose of this section is to provide royalty owners lien under the conditions provided here therein. That was Mississippi Code 53341. And that completes Title 53. That completes cooperative development operation under lease. Exploration, transportation, navigable waters. I think that's where we're at. Anyways, wait, were we this one? No, we're still in development, production, distribution of gas, oil. That was in general. And now we're under cooperative development operation under lease.